Someone make it make sense.
Probably a couple.
Hello, everybody. Welcome back if you were here earlier, or welcome for the first time if you weren't, for our second live stream of the day. So earlier we were covering Bryan Kohberger, and now we are here for some Shanna Gardner coverage. So I'm just making sure I've got all my documents ready to go. Okay, I think I've got them all. Okay, coolio. Hi, Candace. Glad to see you again. Excellent. So we've got the return of Candace. Awesome. Love it. Hopefully Black Widow fared well with her Scotch tape scenario. I would expect we will see Flash as well. I know he was going to take a nap in between streams. So I have every reason to believe, though, he will be joining us as well. And hopefully we will see some other friends, squirrel friends as well, because we do love the squirrel crew here. So yes, indeed. Okay, Candace, I can't remember. Have you been here for some of the Shanna Gardner coverage before, or is this your first time? I can't, with so many different cases and live streams I've been doing lately, it's hard to keep it all straight. But let me know if you, actually now I feel like maybe you have been here. I'm trying to remember. But yeah, let me know if you need a rundown on anything. I know, right? Me too. Candace says, I have a vision of Black Widow wrapped up in a tape mishap. Yep, I know. Me too. Oh, that's so funny. Yeah, definitely. Okay, that's what I thought. Coolio. So we're going to get to spend some more time with Jose Baez, which is, well, actually, I don't know if he appears. I can't remember if he appears, because we're going to watch some of these hearings, and I don't remember if he appears in the hearings, but he appears via these filings, that's for sure. All right, so first one. So we are getting caught up. So this is from August 23rd. And she's cursing the tape. I know, for sure. And Black Widow has a beautiful accent as well, Irish. It's like incredible. Okay, so here we are. Yes, August 23rd of this year. So this is defendant's motion to compel discovery. Subpoenas issued under section 27.04, Florida statutes to out-of-state witnesses. Out-of-state witnesses. Okay. So in support of this motion, Ms. Gardner would respectfully state, 1, a state attorney in Florida has certain investigative powers. And then here's what it says under the Florida statute. A state attorney may summon witnesses from throughout the state to appear before the state attorney at such convenient places in the attorney's judicial circuit and at such convenient times as may be designated in the summons to testify before him or her. Emphasis added. A state attorney's power to summon witnesses for investigative purposes is limited to the authority laid out in the statute. A prosecutor must do more than issue the subpoena to the witness. The state attorney must be present and lead the questioning of the witness. And while law enforcement officers may be, and perhaps should be, present during such investigations, they cannot be the only people conducting the questioning. Okay, so what's this about here? It has come to Ms. Gardner's attention, as demonstrated by the attached subpoena, that the state attorneys and their law enforcement agents in this case were obtaining and using subpoenas under section 27.04 to compel witnesses outside the state of Florida to appear solely before law enforcement and to appear at places outside the 4th Judicial Circuit and outside the state of Florida. In addition to subpoenas being obtained and issued in violation of Florida law, such subpoenas were also not domesticated in the foreign state, but nevertheless served by state agents under threat of contempt for non-compliance. Laws of other states may have been violated in the process. And we did hear a whiff of this at the last crazy, spicy hearing where it seemed like he was like making up fake subpoenas, but there was like, it seems like he was using those with maybe the people like who what were they called? Like the the PR firm, and then also it seems like there was threat of a subpoena that didn't exist with Kimmy when they showed up and pounced on her going to the grocery store. And I think there was maybe another instance of that as well. The full scope of the state's violations of the laws of Florida and abuse of authority are unknown, and Ms. Gardner must obtain copies of all subpoenas issued by the state attorneys in this case to determine whether a prosecutorial misconduct motion is appropriate. Another one. And if you guys saw the thumbnail, you might see that we indeed will have that coming. To date, the state has not turned over any subpoenas issued in this case to witnesses out of state. And I do agree, it is very bananas. BANANAS. We're for. Okay, and there's my hero, Jose Baez, Esquire. Okay, so now that was the 23rd. So now we're going to move to August the 27th. Here we go. Third time's a charm. Memorandum in support of dismissal for prosecutorial misconduct. Okay, on Friday, August 16th, this honorable court sua sponte raised the sanction of dismissal for a discovery violation and queried what authority allowed the court to dismiss the charges against Shanna Gardner. That August 16th, that was the spicy hearing that we just watched. AKA, it was like the second bond hearing, basically. In response to a discovery violation, the court has the authority under FLCRIMP to enter such order as it deems just under the circumstances, including dismissal. The defense renews all arguments for the previously requested sanctions, but seeks to fully consider the authority on the specific sanction of dismissal. Now, here's why this matters, because if you guys remember in the spicy hearing, I pointed out that initially, so in between their second, I guess, request for dismissal and that hearing, they learned more. And so in that second request and also, reconsideration for bond, the remedies that they had listed did not include dismissal. At least I didn't see that. And I mentioned that in the live stream. I was like, oh, it looks like they didn't ask for dismissal. They were asking for other remedies. But then what happened was during the hearing, he was asking for dismissal. And then Judge Kite actually asked him to kind of clarify because that was not in the written motion. And then you actually heard Mr. Mizrahi point that out and was like, they didn't ask for dismissal. So this makes sense that this is being filed as in doing the due diligence. Just to be clear, we are asking for dismissal. The defendant stands before this honorable court charged. Okay, we don't need to go over that. The defense does not deny the tragic shooting death of the decedent by Henry Tenon. However, there's no evidence in support of Shanna Gardner's alleged participation in the fatal shooting on February 16th, 2022. Furthermore, the defense remains steadfast that Shanna Gardner had no participation in any conspiracy to solicit the shooting death of the decedent. On August 16th, the defense fully revealed that the state had fabricated the evidence of conspiracy to mislead the court of Shanna Gardner's knowledge of the decedent's death. Yeah, that hearing was insane. Based on discovery violations, the defense previously requested that the court enter an order granting the following relief. And here's what they asked for. Special jury instruction to draw an inference in favor of Shanna Gardner that the jury may view that after being placed under oath, Detective Christopher Johns of the Jacksonville Beach Police Department made false statements before this court regarding the investigation of Shanna Gardner. 2, excluding all text messages between Ms. Jensen and Ms. Lee. 3, excluding all alleged statements made by Ms. Gardner as alleged to have been relayed to the state by Ms. Jensen during the July 2023 interrogation. Of course, that was the one that wasn't recorded. 4, granting Ms. Gardner a bond upon consideration of the state's conduct and statements of Ms. Jensen and Ms. Lee. And 5, disqualify the Fourth Circuit State Attorney's Office to ensure Ms. Gardner has a conflict-free and ethical prosecution of her pending charges. Shout out to Flash. Glad you're here. How was your nap? The court, upon finding a discovery violation by the prosecution, may dismiss the charges on the authority of FLCRIMP. And there's some more case law here. Oh, they're saying Giglio here. To establish a Giglio violation, which is sometimes sort of grouped in with Brady, but it's a little bit different. A defendant must show the following. 1, the prosecutor presented false testimony. Check on that. 2, prosecutor knew the testimony was false. Yep. And 3, the false evidence was material. Yeah, I would agree with all that. The Florida Supreme Court explained material for the third prong of Giglio violation that the trial court must determine whether there's a reasonable likelihood that the false testimony could have affected the court's judgment as the fact finder. And of course, why does that matter here? Because the court's judgment, right? In terms of the bond hearing, the court is the person who's judging and fact finding, right? The defense filed a motion to release the defendant on bond to prohibit the state from using certain evidence at trial. I'm not going to read that entire long title. The pleading included sworn affidavits. Then on Friday, August 16th, 2024, The motion was argued to the court with competent and substantial evidence that the prosecutors intentionally misled this court with false testimony as follows. Dude, the thing about the check was insanity. Of all of it, I briefly, like, I'm just remembering with the wrong year. I can't. False presentation of bank statements in a murder for hire allegation. The trust funds presented by the prosecution relied upon by the court were funds tied to the legitimate payments in 2021 and independent of any illegitimate purpose. Insane. Misrepresentation of, quote, hitman text messages. From 7 years prior to the homicide, the prosecutors and Detective Johns failed to inform the court that witnesses explained the hitman messages were a 20-year-old standing joke. DSN. Where have you been? And I'm so happy to see you. This is like, I don't even know how to properly celebrate that this is happening right now, but I do know one thing we can do that is essential for this, because DSN. Give me 1 second.
This is a chicken.
Hey, he's got a bird in his mouth. Hey.
This is a chicken.
It's a guinea.
I know I say this every time, but I love that you can hear them in the background squawking, the birds. I'm so happy to see you, my friend. How are you? We have missed you. Oh my God. There it is. See? There it is. Oh my God, DSN. I'm so happy to see you. Oh my God. I remember you were like, I'm going to take a break for trials and watch sports. And I was like, that's a bad decision. That was a long time ago. And I guess the sports have been, maybe you're tired of the sports, but I'm happy you're here, DSN. Please let us know how you're doing. Okay. Been watching sports lately. Yeah. Sports ball stuff. Oh my God. By the way, Flash is a new squirrel friend. So just introducing you guys here in the chat. I'm sure you guys will just love getting to chat with each other and chat it on up. We've got so many new squirrel friends, but of course we got the OG crew as well, still holding out the holding down the fort, as they say. So the hitman, yeah, this is so insane though. This is insane. The funeral potatoes. Speaking of, isn't that funny? Because we were talking about the cheesy potatoes earlier today. The funeral potatoes text messages were misrepresented as code for the killing of the decedent. I mean, how can you even, like, I'm trying to read this and not laugh, and it's really hard. It's really hard, especially given the whole Mormon context. The prosecutors failed to inform the court that the church members prepared funeral meals for members of the LDS church family community. The statements, "I'll take care of it," or "missed opportunities," were known as catchphrases often repeated by Mario Fernandez and were made independent of the charged homicide. Detective Johns falsely testified concerning his interactions with Linda Lucetti and Chris Thomas in Utah. Linda Lucetti did not hide from Detective Johns. The exculpatory interviews between the prosecutors and Kim Jensen were not recorded. And that's not even all of it. Like, that right there is like, I mean, yeah. One of the first two prongs of a Giglio violation are established. The state bears the burden of showing that the false evidence was immaterial by showing that its use was harmless beyond a reasonable doubt. Here, the court ordered denied bond in reliance on the false evidence. This material harm of denied bond satisfied the third prong. I've been combining words all day today. Or what was it earlier? Shank was an earlier one. We got shank and we've got certified. After the hearing on August 16th, the defense satisfied all three prongs of a Giglio violation with competent and substantial evidence. It is established that a conviction obtained through the use of false evidence known to be such representatives by the state must follow the 14th Amendment. And here's some more case law, all the case law. The sanction of dismissal is available for the due process violation of knowingly using false evidence on the authority of Giglio versus the United States. The court has legal authority to dismiss the charges. On Friday, August 16th, after several hours of testimony and over 1 hour of argument by the defense, the prosecution argued to the court that the defense failed to impeach Detective Johns when he testified on May 17th, 2024. The prosecution presented no evidence to refute the defense. They also didn't provide any case law. The prosecution did not deny that they knowingly put Detective Johns on the stand to make several false statements of fact to the court. Moreover, to this day, the prosecution fails to correct the multitude of false statements and material facts relied upon by the court. But for, I love a good but for the independent witnesses, Susan Lee, Kim Jensen, Lil Lucetti, who reached out to the defense, that's me inserting that, they contacted the defense, review of the Arthur hearing on YouTube, and their individual efforts to notify the defense counsel, keep reading Chelsea, there would be no ability to raise these issues to the court in a timely manner. It cannot be overlooked that the prosecution was aware of these issues and failed to notify the court. Shanna Gardner, through no fault of her own, was substantially and materially prejudiced in her ability to prepare her defense in the Arthur hearing due to the multitude of false statements that were relied upon in the court's order denying bond. Under Flacrimp, the prosecutor shall disclose to the defendant any material information within the state's control that tends to negate the guilt of the defendant. Duty to disclose. In Florida, the rules for discovery violations authorizing the sanction of dismissal were never intended to furnish a defendant with a procedural device to escape justice. And see, there's Richardson, because we know the Richardson hearing, it's one and the same. In this case, jeopardy is not attached. It is an argument against dismissal for Brady discovery violation. In the instant case, the ongoing pattern of prosecutorial misconduct is overwhelming and without any recognition of wrongdoing or any signal toward change. Totally agree. Here, alternative sanctions would only bolster the prosecution to continue their misconduct. And it looks like there's a, what is that? Oh, footnote. Okay, so I was so confused by this in a box that, okay. The defense has demonstrated more than a Brady violation, but an egregious series of Giglio violations. This is not a case of overzealous advocacy, but rather the prosecution deliberately misleading the court in a successful effort to deny Shanna Gardner's constitutional right to due process under the law. Here, all three prongs of a Giglio violation are established. The court can and should sanction this prosecutorial pattern of misconduct of due process violations with dismissal. Therefore, Shanna Gardner respectfully responds to the court's request. Do all the things. They are TARs. They're all TARs. Yes. Oh, they totally are. Haha. Very funny, Flash. DSN saying he's also a huge fan of the naps. So Flash, are you modding right now at the moment? Flash mods for a couple different channels, and so oftentimes is modding while also here in the chat. By the way, DSN, we have some new fun little things too, if you want to see those, some little videos. I may have posted these in the Discord, but I don't know if you have seen them. But we have some more, we have some new fun squirrely things. So that takes us to, so that was August 27th. So that brings us to September. And I do believe next up is a hearing. And so I think it's September. Let me check. September 23rd, hearing. So do the old unshare, reshare situation. Here we go. All right, so
the defendant's motion and all of these things amount to this. So in the form, this court did the analysis on the grounds raised by the defendant, and also viewing the defendant's motion related to the different areas, the remedies. I've addressed each one of those. So I'm going to deny it, but it's without prejudice because obviously discovery is ongoing, and I don't want the defense to be under the impression that you can't bring this to the court's attention, or if it remains that I would then readdress it. Does that make sense?
It does. And I'm understanding the court's position. So if some new information comes about, we could refile this particular motion.
So not just again, remember, just like before with these bond motions, like they're being denied without prejudice. And so this has already happened twice. And now this is the third time. So in other words, if there's new information that comes out, they can file it again.
Asking for limine, but this particular motion
bond, it's more than, as you guys saw, they're not just asking for bond. It's bond, but also dismissal of the charges and disqualifying the state attorney's office and myriad other things.
Since denied without prejudice.
Yes. So I think that the request for a jury instruction, that's not ripe yet. Or I
Right.
have to
Not
analyze
right.
that under a different standard. Additionally, the request and the argument by Mr. Bias at the last court date to release her on bond, I don't believe this is the proper motion or vehicle in order for this court to review that. I've reviewed it based on the papers,
Also glad
reviewed it based on the Richardson analysis. And
Guys,
if you
I'm so happy to see y'all. If anyone is unfamiliar with this case, let me know. Welcome to everybody who is here. Glad to see you guys.
believe these things to, just like the rule says, 3.220 if there are things that remain. And I know the defense has brought several issues to the court's attention. Mr. Bias argued for a really long time, cumulative. At this point, I've analyzed it related to the issues brought to the court's attention. And I don't believe that there's a discovery violation. That's what I found. However, if these things remain, if it continues, I want the defense to understand the court's ruling. You can bring it to my attention again. Okay.
And not to belabor the point, because I didn't ask this specifically, is the defense permitted to refile or renew the request for an argument?
Yes, you can do whatever you feel as though is appropriate. I've addressed what you brought to my attention, is what I'm saying.
I believe who we see arguing right now is Rosemary, I think Peoples, from the Baez law firm.
You understand? The discovery violations, there was, in my view, Mr. Bias was arguing
I'm interested.
The discovery violation / something that was not before the court. Does that make sense? Misleading the court.
I don't agree, but I do understand the court's position.
Okay.
Yes.
So what she's saying, what Judge Kite is saying, is that there were myriad issues. It's tough when you've got so many issues. It's unusual, right? So there was the discovery violation, but the misleading the court, that was what he was saying is the prosecution was misleading the court, right? In a lot of ways, right? So that was separate but equal, but also congruent to the bond, right? Because like the misleading the court is a problem anyway, right? But also the misleading information is what Judge Kite based her decision on when she denied bond.
So I'm doing it without prejudice.
Thank you, Your Honor.
No prejudice.
And I believe that the next defense motion then would be motion to compel.
What's the state's position on that?
Is this the motion to compel?
So the motion to compel, we just read this. This is the subpoenas, the out-of-state subpoenas, right? And there you can see the subpoenas. So we just read that. And so as you can see, by the way, there's the lead prosecutor, Miss Stifler. It's funny because we got Miss Stifler, we have Judge Hippler, but I call him Judge Stickler, sometimes Judge Grinchler. Anyway, a lot of rhyming going on.
Subpoenas?
Yes.
I'm in agreement with providing discovery if it exists. I've spoken to my detective and am in the process of speaking with ATF. I believe that there was only one subpoena
I like this bailiff.
served, the one from Ms. Luchetti, which they're in possession of. At this point, I don't believe there are other subpoenas served, but I don't know that for sure yet. And if I find out otherwise, I will provide those to defense counsel. So I'll fulfill it if I can. If that discovery exists, I will provide it.
Oh my God, I'm just having flashbacks to Brian Koberger and all that, right? Oh, it doesn't exist. It's imaginary. No videos, no discovery.
When will you know?
I'm supposed to have a call with ATF today. I spoke with Jacksonville Beach Police Department last week.
Okay.
Another thing that's interesting about this case is that oftentimes we see that there's cases where they utilize the FBI, and the FBI, as I say, usually is like all up in this case, like Casey Anthony, for example, they're all up in the case. What's really interesting about this one is they didn't use the FBI at all, but they used the ATF and they used like the Secret Service. So they still have lots of involvement with these federal agencies, but they did not use the FBI.
All right. So I'll grant that by stipulation. What about the motion for the transcript of Detective John's?
Love the
States objecting
courtroom.
to the motion. I provided counsel with case law, and I have some for the court as well. May I approach?
Yes.
She's approaching.
Your Honor can review the cases. They basically state for the long-standing tradition of grand jury proceedings in our country are meant to be secret to ensure the integrity of the justice system in both cases.
Okay, so what this is about is the grand jury transcript. So this has been a big topic in this case as well, because Kim Jensen was like, to our knowledge, right? They're secret, but Kim Jensen seems like was the star witness of the grand jury proceedings. And remember, we heard this in this crazy spicy hearing from last time. The circumstances under which they brought her to that grand jury proceeding and like basically intimidated the crap out of her. The prosecutors, Mr. Mizrahi especially, intimidated the crap out of her and was like threatening her with what? It was like 30 years jail time, he told her. Was like saying, if you lie on the stand, it's like 30, you will put you in jail for 30 years or something insane, like insanity. And she was like terrified. Oh my God, it's just horrifying. And so she testified at the grand jury, and he then like told her that it should have felt like an interrogation. If that's what it felt like, that was correct. Weirdness. And so it's just a fucking mess. So that's really what they're wanting is from the, that's what, when they're talking about the grand jury, all that we've heard of that they're asking or talking about is as it pertains to what Kim Jensen said, right? Because again, the duress was there clearly, but then again, just to remind everybody who doesn't know, Kim Jensen came out like, so you had the grand jury, right? And then they basically kidnapped her kind of, and interrogated the fuck out of her and called her a co-conspirator. And that was a whole thing. And then that interrogation was not recorded and, or videoed. And then that fast forward to this year in the summer when they started having the Arthur hearings. And right before that, the detective Johns shows up at her house unannounced and is like, hey, just so you know, like there's going to be this hearing and it's basically a mini trial, which I mean, it kind of was, but I can't believe that they said that. It's insane to me. And that like, we just want to make sure you're safe. And she was like, what the fuck? And it was all weird. And then she watched the Arthur hearing on YouTube. And when hearing how much they lied about what she said and misrepresented her text messages and misrepresented everything, her statements, you know, that's when she reached out to the defense to say, no, this is not correct. So essentially, it's just a mess. This is the Microsoft exec, correct? Oh, I missed the suitcase joke. I don't know. Are things not coming up in the chat? I missed your suitcase joke, DSN. But yeah, suitcase jokes are always welcome here, man. We love a good suitcase joke. So yes, I mean well, having said that, I feel like there's so many of these murder for hire. So just to clarify which murder for hire, right? Yeah, this is the Microsoft exec, Shanna Gardner, and her estranged husband, Mario Fernandez. They are, by the way, they are being tried jointly, which is another interesting factor, right? Her and Mario. And they're both, the state is seeking the death penalty for both of them as well. So I hopefully, I don't know if something's happening. I missed the suitcase joke. I don't want to miss any of DSN's jokes because DSN makes the best jokes. So, but yes, the suitcase jokes are definitely welcome.
Brookings versus State 495 Southern 2nd 135, which is the Supreme Court of Florida. The court does the analysis, and this is on page 3 of the opinion. There is no pretrial right to inspect grand jury testimony while holding an in-camera inspection of such testimony is within the discretion of the trial court. The court discusses their decision in Gent, J-E-N-T, which is a cited case, that a mere surmise or speculation regarding possible inconsistencies in testimony is not enough to require the production of grand jury testimony. They discuss the importance of maintaining the secrecy of grand jury proceedings and that the parties seeking the disclosure must make a strong showing of a particularized.
Correct. And this is a good opportunity to just sort of, for anyone who's not as familiar, that's correct. So that he was shot by Henry Tenon. Now remember, Henry Tenon, this happened in, February of 2022. They did not make any arrest or whatever until almost a year later. It was January, I believe, of 2023 with Henry Tenon. And he subsequently took the best plea deal of all time if you're him, basically, right? Now, he had a prior record, and I've talked a little bit about how I wonder how that played in. But what's interesting, right, is that the checks that in the prior hearings that the checks that the state presented to try to show the whole thing, right? Because the only connection of Shanna and Mario to Henry is the money, right? That they hired him because the thing is, his last name is Tenen. He was also a tenant of one of their properties, and he also did legitimate work for them, which he was paid for. And the state said that. So the only way that they can connect that they paid him and hired him to kill Jared Bridegan is through the money. Now, what happened previously was that the state presented these checks and put them on the Elmo, and we saw them, and the state said, like, you know, these are the checks, this is the payment, this is the down payment for the murder, blah, blah. And they kept using the months. And it wasn't until the most recent bond hearing that we covered last time, the really, really super spicy one, although they've all been spicy, where Mr. Baez realized, this is mind-boggling. They had everything they were presenting was from 2021. So in other words, they were putting up checks from 2021 and representing them and asking questions as if they were from 2022, because that's when the murder happened. It's insane. And that's what they're relying on. It's the wrong year. Like, what? So in other words, what would have been potentially maybe one of the strongest elements, and just in terms of trying to prove the basic elements, right, of what they're being charged with, right? They had to have had conspiracy. They had to solicit, hire someone, right? You need the finances, right? And it seemed like cut and dry. Here's the checks. Okay, that looks pretty bad. Oh, wrong year? Are you kidding me? And we learned in the last hearing too, that the checks from the actual correct months and the actual correct year, there's like a 3-month window, the state has not presented or turned over. But if that, like, oh my God, it just doesn't. So, right. So what do we know? So Henry took a plea deal. But again, you have to wonder, given that he had a history and the charges he was faced with, you have to wonder if what happened in that interrogation room, right? Because what happened was, apparently, right, the whole thing is that Henry described these checks and said they were from the year and said this is payment for the murder. However, when you look at the dates, that's impossible. So was it a false confession? That's kind of where I'm left wondering, was this a false confession? I don't know. That, right. But the thing that's so crazy is that the way the state presented it was that it was actually a joke. It was like they were joking about it because of the fact that the checks came in after the murder, and they said that they joked about it because they're like, the plan was that he was supposed to commit the murder without being paid and be paid afterwards in an installment plan. That was what the state said, which also doesn't make any sense, right? That like you're going to commit a murder without being paid and then you're going to get paid in installments. That's what they presented. And that was supposed to be based on what Henry told them when he confessed or whatever. And so they presented these checks and said, oh, the reason it's from March, even though the murder was in February, it's 2 months after. That was the plan. And then that was the first down payment. And they really only have the one check, the down payment or whatever. But it's not even that because it's the wrong year. So it doesn't match. In other words, the dates on the checks don't match with A, what the state represented, or B, what allegedly Henry Tenen explained in the confession. Right. Yes, the similarities to the Adelson case are it's crazy. Classic double extortion. Yeah, right. I know. Very on point there, DSN. Thank you. Yes, very on point with that. Very astute. Yeah. Yeah, it's wild. It's wild. For sure.
Need in order to outweigh the public interest in secrecy. The other case the state cited, Bing versus State, 323 Southern 3rd, 830. In this case, the first DCA considered a request to unseal grand jury testimony, but denied it, finding that numerous alleged inconsistencies among state witnesses were an insufficient grounds to grant the motion, where defense is able during cross-examination to direct jury's attention to any purported inconsistencies between the witnesses. And also it analyzes a request to unseal grand jury transcript in order to determine whether the indictment was maintained upon perjured testimony. In this case, the court found that mere allegations of inconsistencies failed to provide a specific basis to conclude that a grand jury witness committed perjury, and the appellant could not seek a blanket production of grand jury transcripts based on mere surmise or speculation regarding possible inconsistencies. and that even when the state's case at trial differs materially from the grand jury indictment, there's no error in the trial court's refusal to dismiss the indictment. Court finds due process is implicated only when a prosecutor permits a defendant to be tried upon an indictment which he or she knows is based
Now,
on
this
perjured
here,
material
by the way,
testimony.
This here little lady who's speaking, okay, ASA, Assistant State Attorney Stifler, just for a little bit more background for anyone who's not familiar, from the get-go was in possession of attorney-client privilege material for both of these defendants. And it gets worse than that because they were supposed to have a taint team, but it was the taint team that, which is what the state called it, was just one person. This one person was not trained and had wasn't provided any instructions. Okay. And this one person was from the Secret Service. And she told him if he had any questions about whether something was in fact attorney-client privilege or not to go ask the other people who were maybe there that he could have asked, but to go straight to her to ask her if it was attorney-client privileged or not. And he did so on, I believe the documents stated it was at least 2 or 3 occasions where he presented her with information to ask her to look at it and say if it was privileged or not. Chew on that one for a second and try not to choke, please.
Without informing the court opposing counsel and the grand jury. In regard to the defense motion to unseal is merely speculative. It contains surmised allegations. There has been no particularized strong showing by defense that there has been any material perjury or any perjury whatsoever in the grand jury testimony of Detective Johns regarding the indictment. And for the reasons outlined in these cases, the state's going to object.
Good one.
So, Your Honor, if I may.
Is this a joke?
Yes.
So, in response, Your Honor, looking at that first case, it's mere speculation that the state is claiming first and second case, and that is not what we have before the court.
You know, and
We
I
have
was literally going to make that argument because the case law that she cited, it referenced speculation and it also referenced like mere inconsistencies. And I didn't pause it, but I was thinking to myself, that's not on point because that is not what we have here. It is not speculation and it goes well beyond mere inconsistencies. So, but she's saying it. So
instance or instances of the lead detective before this particular court making false and misleading statements of material matters to this court.
By the way, another little tidbit for anyone who doesn't know, this lead detective on this case, okay, when he was the lead detective on this case, he had only been in law enforcement for like 3 years, maybe less, maybe 2.5 years. And it was his first homicide as well.
So now we are asking, based on what we know to be false representations of Detective Johns, for his testimony before
Detective Johns is the guy I was just talking about, Detective Johns.
Grand jury. Because if he's made those false statements to the grand jury, then we are moving forward on an indictment based on perjured testimony.
Okay.
The only way we can verify that, Your Honor, is to actually have the grand jury testimony. But what exactly are these false statements?
Now,
the court's aware that they've received.
Real quick. Do you guys remember when this came up in Murdoch? Now, it wasn't nearly as big of a deal in that case, but there was something that came out during the trial with all the other things that came out during the trial. There was something that came out about, and we don't know all the specifics because grand jury testimony, but about something about the grand jury testimony, right? And they kind of brought it up in cross, I think maybe a little bit, but it had to do with like, I don't even remember. It had to do with something about which firearm was used or something like that. And it was one of those things where it could have been a huge issue depending on what it was because of exactly this purpose, right? If you make knowingly and intentionally false statements or false statements, I guess, period, under oath to a grand jury and they indict you based on that information, problems. But it was determined, I suppose, I can't remember exactly all the specifics again, but that it wasn't, it was either accidental or incidental or both, right? Like it was like he misspoke or, and it wasn't material to, like it wouldn't have made a difference. Is what I think they concluded. But just to use that as an example, because if you guys remember when that came up initially, it was like, oh no, right? So yeah. Oh my God, I know. Michael Proctor, right? Yep. Now I'm just thinking about Trooper Paul as well.
The state made a representation to Detective Johns about 3 checks. The checks initiated or the funds allegedly initiated from the trust of Shanna Gardner. What the state did not argue or present clearly to the court as part of this misrepresentation is that the trust
Did she already go to trial? Are you referencing Karen Reed or are you referencing Shanna Gardner? Karen Reed had her first, well, I feel like you probably know that. Karen Reed's waiting on her second trial, right? That has been continued until April Fool's Day. And Shanna Gardner's trial, again, she's being tried jointly with the co-defendant, Mario Fernandez Saldana. That is scheduled for October of next year. So it will overlap more than likely, unless something changes, it'll overlap with BK, Idaho.
trust funds that they presented were from 2021. The checks to Tenon were in 2022, but it doesn't stop there. The funds that they showed from 2021, the balance on that very same check resulted in $1,900 and I believe it was about 25 cents. The check to Tenon was for $5,000. So again, clearly the funds that they're showing coming from Shanna Gardner's trust fund weren't related to the check that was provided to Tenon. The theory of the state's case is a murder for hire.
Yes.
The funds that they're showing aren't related.
This is what, y'all, this is an opportunity for me to roll one of my little clips for anyone who hasn't seen it. But you know what? That's like literally what I was saying. Like if they can't prove murder for hire, they have nothing. Like that is the basis of all of the charges here, right? The solicitation and the conspiracy. So like if they don't have the finances worked out, bye-bye. So, but here's the thing. I said that earlier. So that is what we like to call here a squirrely crystal ball moment. So magical.
That's material. They also made a representation to the court of a truck that was driven by Tenon, and an allegation that only the individuals involved with the murder for hire would know about this truck. Why is that a problem? Because they failed to demonstrate to the court or show to the court that the roommate, Ordway, was well aware of the connection based on testimony or based on an interview by law enforcement. So these aren't minor or insignificant issues. These are material misrepresentations, whether it's the truck, whether it's the fund, but it doesn't stop there. And again, this is all through Detective John's representations to the court. There's the text messages that Detective Johns was well aware was based on a joke from some 20 years prior. And what did the state present to the court?
Also, by the way, not just a joke from 20 years prior, a joke from 20 years prior between two other people that are not charged in this case. It's not even like an inside joke between Shanna and somebody. It's an inside joke between Kimmy and Sue from 20 years prior.
Text messages, absent the context that this was a very old joke, absent the context that there was a text marked LOL.
You guys, Mr. Mizrahi is standing up and approaching the podium.
So to say that this is mere speculation when we can point to verified
or no, that might not be him actually. It might be somebody else. Kind of hard to tell.
Instances of misrepresentations by Detective Johns before this court, and knowing that he is the main witness, or at least it appears he's the main witness before the grand jury, his testimony has been perjured as we stand here before this court. So that's why we're trying to get through and get the actual testimony before the grand jury, because if the case should proceed with this perjured testimony,
it's also not just Kimmy's testimony they're trying to get from the grand jury, but yeah, of course, they're also trying to get Detective Johns's
testimony. Shanna Gardner's due process rights are in jeopardy. We are trying to have a fair trial and a fair opportunity for Shanna Gardner's case. So this isn't a fishing expedition. We're not asking for every witness that testified before the grand jury. We've narrowed it down to specifically Detective Johns based on his material misrepresentations to this court already. And it's a fair connection to say that he's made similar, or if not greater, misrepresentations to the grand jury. And the only way we're going to know that for sure is to actually get that grand jury testimony of Detective Johns.
I think this attorney is doing a great job laying out this very well, logically, linearly. She's doing a great job.
For that reason, Your Honor, based on all the argument that's before the court in this written motion, we're asking for the court to unseal Detective Johns' testimony, not for a fishing expedition, but to verify that this indictment that we're all before this court on is actually valid.
Well said.
Not based on perjured testimony.
Well said.
Can I just ask a practical question to the state? Why did you agree on other witnesses and you're not agreeing on this one?
Because I was fulfilling my Brady.
It's interesting. This judge, finds herself in a position where she oftentimes needs to ask questions of the state, like, why did you do such a thing or not do such a thing?
The obligation, knowing that Ms. Jensen had withheld or given inconsistent testimony at another time. I have no such misgivings about Detective John's testimony.
So you're saying to me that you've reviewed the testimony, the grand jury testimony, and these areas that the defense is pointing out, these 3 areas, there is no Brady in the state's view.
I do not have Detective John's grand jury testimony because it's sealed. I obviously was present for it and have my notes from our pretrial and from the actual presentation of testimony, which was very significantly similar to the sworn affidavit he gave on the Title III wiretap affidavit, which they have possession of.
Yeah, what's funny, just again, another overlap there with the Adelsons, that they also had a wiretap.
Can't recall specifically these issues. I don't believe there was much discussion of some of these, but I can't say for sure. I haven't reviewed the transcript. But what I would say is they're talking about testimony that came out at a bond hearing regarding the detective's testimony on hearsay. So he's saying what other witnesses have said. We haven't deposed these witnesses. We haven't deposed Detective Johns. They haven't even asked him what he testified to at grand jury, or they haven't even asked him directly about these issues, vetted these out through discovery. So I think at this point, they're saying what they perceive to be misrepresentations, which I disagree with. I think that 2 parties can look at evidence differently, have different theories of a case and different theories of evidence. That's why we have a justice system and trials. They're saying
there's a lot. Yeah, it's a lot of screwy stuff going on for sure. And different, again, different than we see in other cases. Like, really brazen, right? Like, for example, the thing with the check is insane. I mean, but I say that again, the list is so long of the brazen, and you guys will see, for anyone who's kind of new to it, you'll see whenever they get into, especially with Mr. Mizrahi, it's like, you'll have like Mr. Bias or one of the other defense attorneys like lay out an argument, and it's like, there's all this case law, blah, blah. And then Mr. Mizrahi will get up there, no case law. None. Yet this entire pre-trial, he's had no case law, and just waves his hands around yelling, and it's insane. It's insane.
Saying that they believe Detective John's testimony is inconsistent with their theory of the case, and therefore there must be, or potentially would be, other misrepresentations in his grand jury testimony.
Right.
That's a speculative statement without any specific substantive or particularized merit from the state's perspective.
Yeah. I feel you on that. It's tough, man. It's definitely tough. It's definitely tough. I mean, I don't think, there's a number of issues in Karen Reed. I don't know if this is to that level, but again, there's also some differences. Like we don't have any red solo cups, you know what I mean? So it's not like, in other words, not like with Karen Reed, the problems started with from the beginning with the way everything was handled at the crime scene, right? So like there's that. It's like the evidence is just useless. Again, in this case, it doesn't seem like there's a whole lot. I mean, it took them a long time, like I said, to even bring charges against anybody. Almost a year is a long time. And again, it really kind of relies on the cell phone, communications, text messages, and the checks, right? From what we really know. And then the confession, Henry Tennant's confession. I mean, really, that's what it hinges on, because confession is considered direct evidence in the court of law. And again, you have to wonder because of the circumstances of that. But anyway, so it's more like what they have is being misrepresented. Like, again, the example with the checks, and I don't know. It's so I can see what you mean about that, though. It's definitely tough to watch. Again, all I can say is at least we don't have a solo cup issue here, but we have other issues that are equally as bad, but just different category, I would say.
I think secondarily, if the court were to be inclined to consider granting the motion, the state would request that Your Honor do an in-camera review of the transcripts before releasing to either side. And if Your Honor perceives there to be anything that needs released, that those particular sections can be released.
I'm going to go back to my original question. So on Jensen, did you have the same information?
Going back to my original question. So that's Judge Kite saying, you did not answer my question. Objection non-responsive, says Judge Kite.
Information, that is your notes. And you made that analysis and agreed with the defense to release it.
So when Ms. Jensen testified at grand jury, she was reluctant to be truthful. She gave some statements, and then at a secondary meeting at the state attorney's office, she gave additional statements. So I believe that to be information that should have been brought to the attention of defense counsel, which is what I did. I had a phone conversation with Mr. Carodi. I told him that Ms. Jensen continued to withhold and continued to minimize her involvement. In my estimation,
By the way, also, again, this little lady, as I'm now calling her apparently, and Mr. Mizrahi, throughout these hearings, they have referenced and called Kim Jensen a co-conspirator. Okay, a co-conspirator. Now you might say, "Oh, that's interesting," because so then what is she charged with? Oh, so she's not charged with anything. They never charged her with anything. Oh, and also she's like one of their key witnesses, according to the state, because of the text messages about the funeral potatoes and whatnot. And they are these. It's so insane. Like, because I kept initially, because I've been going in chronological order, I was really confused because like a co-conspirator or what? There's only 2 people. Well, 3 people total, right? But there's 2 people being tried. Like, who co-conspirator? What? Who else are they talking? And then I realized, wait, they're talking about someone. They're talking about Kimmy. What? And then like, and that's what they call her, a co-conspirator.
And that she had given us additional statements at a meeting subsequent to grand jury that she did not disclose at grand jury. And I believed that meant.
I know, reluctant to be truthful. That stood out to me as well, because that's in their estimation, right? In other words, what that means is she didn't say what, they likely want. And again, they didn't skimp on the intimidation prior as well, with like 30 years of jail for making a false statement at a grand jury. Meanwhile, calling her a co-conspirator, but not threatening her with any charges related to that. So,
while it was not necessarily Brady because it did not tend to exculpate the defendant, the fact that a witness gave additional statements that she did not disclose under oath, I believe that they should move to unseal the grand jury testimony. I told them so. It's in the email that Mr. Crody that we entered at the last hearing. It's in their motion to unseal, and I had no objection.
I don't think she's still
in this case
the question.
Their motion has presented nothing to the state that leads me to believe there's anything that they're entitled to receive that is.
This is, Ms. People, do you want to be heard?
Sorry.
I think what I'd like to do is before.
She still didn't answer the question. Just saying.
I'd like to read these cases, and I would ask that the state look at whatever testimony, make an analysis of what you believe, and I will take it up again. So,
if I may, Your Honor, just
sure.
a brief point, just making that distinction in the second case, Bing versus State, 323 Southern 3rd, 830. And this particular case ends with because the defense conceded. There is no concession from the defense on this particular case or the material facts that we're arguing in this particular case. So I bring the court's attention to the distinction between the cases brought before the court.
Okay.
Where we have the perjury and we're not conceding to the information that.
Do you have any cases you want me to read?
Other than what's cited in the motion? No, Your Honor.
I'll take this under advisement.
Under advisement.
I mean, maybe on a review, the state will change its position. If not, then I'll make the ruling. Okay. But I'm going to take this one under advisement. I've granted the other one. Motion to compel the subpoenas. I'm going to grant that by stipulation.
Okay.
What else is left for today from the party's perspective?
I believe that's all for the Gardner case, Your Honor.
Okay. Mr. Dreiser, do you have any? I have some things I want to cover.
Okay, so now for anyone who doesn't know, now here comes Mr. Dreiser. So he's representing the co-defendant, Mario Fernandez Saldana.
The only update that I have is there was an issue about deposing the children at the last court date. We have done that. Those depositions are done. So I just wanted to report that we were able to work all those issues out and get those depositions accomplished.
That's great.
And we have depo dates going back and forth for many different witnesses and different state, civilian, and federal witnesses. And I think we're working through the remainder of the discovery issues. And at this moment, I don't see any court intervention being necessary.
Okay. When are the depo dates?
We were kind of going back and forth on which witnesses this.
Go forward a little bit because we don't need to hear about them talking about the depo scheduling. Let's see what this is. Oh, it's just another spinny wheel. Just another spinny wheel. Shout out to Iowa. Happy to see you. Iowa, in case you didn't notice, DSN's here.
We just email him a 2-week letter tomorrow.
What is this? I just have to say, guess who's back? Like Dr. Dre, right? DRE. Instead, it's the DSN.
And I would be
very flexible.
Sir, if you need this, I'd be certainly. I would email you the depo dates that we select.
I would like those.
Sure.
Okay, let's see if anything else happens here besides the depo dates. Okay. Okay, I think we're good on this. So now we have the next document. So let me pull that up. So unshare, reshare, unshare, reshare time. Oh my God, I'm just going loopy today. Okay, so let me pull my banner down. So this is the same day. So remember, the first thing that they talked about at the hearing that we just watched was having to do with the bond, but remember, without prejudice, right? So this is the actual, order of what was discussed for as it pertains to the bond. So is this okay? Yeah, it's sharing. Okay, good. So order 9 bond, motion to blah, blah, blah. So what'll be interesting to see is what the grounds are on this one and how it's different from the first one. So a hearing was held on defendant's motion. At the hearing, defendant presented testimony of the people. Following the hearing, defendant filed a memorandum in support of dismissal for prosecutorial misconduct on August 27, 2024. In the defendant's motion, she alleges the state made multiple discovery violations by failing to disclose Susan as a witness and an unrecorded interrogation of Kim Jensen. Footnote 1. Defendant also makes argument about whether Ms. Gardner knew Henry Tennant's truck had been used in the murder, but it only does so to contextualize the 2 alleged discovery violations. Richardson discovery violation standard. To satisfy the threshold requirement of a Richardson violation, the defense must show a discovery violation occurred. Pursuant to the discovery rules, the prosecution is required to disclose to the defendant the statement of any person who is a witness and may have information related to the charged offense or any defense. The rule further defines a statement as a, quote, written statement. Now she put that in italics. A written statement made by the person and signed. Okay. So in other words, oral testimony, like such as at a grand jury, would not count. It's a written statement. So that is important. No wonder she italicized that. Wow. Okay. Look at, but look at that, writing or recording. And again, like that interrogation was not recorded. The state, however, is not required to disclose a witness's oral statement when that statement was not written or recorded unless the information in the statement is Brady material. Brady material constitutes evidence favorable to the defendant because it is exculpatory or impeaching. Well, I would say it counts as definitely impeaching, if not maybe exculpatory, but definitely impeaching. Once a defendant raises a discovery violation claim, the court must conduct a Richardson hearing. We saw that in Sarah Boone, inquiring into whether the discovery violation was willful or inadvertent, was substantial or trivial, and had a prejudicial effect on the aggrieved party's trial preparation. As to the the last prong of the analysis, prejudicial effect refers to the procedural prejudice rather than the substantive prejudice. This means the defense's preparation must have been prejudiced by the ambush, not necessarily that the substance of the changed testimony strengthens the state's case or implicates the defendant. Omission of Susan Lee from the witness list. In ground A of the defendant's motion, she alleges the state committed a discovery violation when it did not list Susan Lee as a witness in its discovery disclosures. So that's where the discovery violation, right, comes in. So defendant claims that she only became aware of Miss Lee on the eve of the Arthur hearing when the state shared its evidence for the hearing. Defendant argues that had she known Susan Lee was a possible witness in this case, she would have performed additional due diligence prior to the Arthur hearing and reviewed Miss Lee's text messages previously disclosed by the state. In light of Susan Lee and her text messages being disclosed to the defendant prior to the Arthur hearing, there was arguably no discovery violation. However, any possible discovery violation of Susan Lee not being listed as a witness cannot be found to be willful based on disclosure of text messages, right? So they're saying because they had the text messages, doesn't count. Upon realizing Miss Lee's text messages were of importance for the hearing, defendant could have moved for continuance. So in other words, there were other less drastic measures that could have been taken, such as continuing the pretrial hearing. So that's a good point. That's a good point. That's a good point that she's making here. That's a good point. She's not wrong there. They could have done that. To investigate Miss Lee as a potential witness in knowledge of her case, the defense objected to the introduction of Lee text messages on other grounds, and the court allowed the text messages to be used as evidence during the Arthur hearing. A defense motion to continue the hearing could have cured the discovery issue. Yep, that's what I was just saying. However, there was no such request. Discovery is an ongoing process, and Richardson hearings are rarely raised during the pretrial phase. Unlike a discovery violation on the eve of trial, there was ample time to reschedule the Arthur hearing if defendant wanted to investigate Susan Lee further. Additionally, defendant's claimed prejudice is too speculative for relief because disclosure of Susan Lee on a witness list would have only added her name to numerous other potential witnesses for trial, and nothing would have set her apart to be investigated from any other witness for the Arthur hearing. And then non-disclosure of the Kim Jensen unrecorded interview. In ground B of the defendant's motion, she claims the state committed a discovery violation when it failed to disclose statements made by Kim Jensen during an unrecorded interview with the state. Defendant alleges, now I wonder here if what she's going to say is because it was oral and it wasn't recorded and it wasn't written down. Defendant alleges during this interview, Kim Jensen was confronted with various text messages between her and the defendant that involved discussions about eliminating the victim. Defendant claims Kim Jensen explained to the state that the text messages were taken out of context. Defendant also alludes to a claim of circumstances of how and when the interview occurred should have been disclosed. Defendant argues this information should have been disclosed prior to the Arthur hearing because it is Brady material that is exculpatory and could have been used to impeach. So again, here I'm like, I don't know about exculpatory, but definitely impeaching though, for sure. Detective Johns' testimony that the defendant was serious about finding someone to get rid of her husband. I mean, yeah, he completely mischaracterized all that stuff. After considering the evidence presented at the Richardson hearing, the state did not commit a discovery violation when it did not disclose Ms. Jensen's statements about text messages from the unrecorded interview because her statements were not, like I said, not memorialized in a written or recorded statement. The state did not have a duty to disclose them pursuant to Rule 3.220. The state does have a duty to disclose any Brady material prior to trial, but these statements are not Brady evidence because her opinions about the defendant's state of mind, right? I guess that's a good point, right? It's defendant's state of mind, are not exculpatory or impeachment evidence. Detective Johns' testimony was based on his view of the evidence, including the contents of the text messages. Detective Johns testified that the defendant was serious in her solicitations, even if some of the people she solicited did not believe she was. So in other words, what the court is saying is they have to go off of what Detective Johns' state of mind is, essentially, like how he views the evidence. Anyway, defendant's state of mind is at issue. Sorry, defendant's state of mind is at issue and not the other participants in a conversation. Even if the state had committed a discovery violation in failing to disclose these statements and circumstances to the defendant prior to the Arthur hearing, defendant is not entitled to any additional relief because there was no prejudice. Anyone can do the commands, any of the commands. Anyone can use them. Here, I'll put it. So you can do hugs. You can do. So if you do, here's the thing. If you do hug, and this is the one I always get confused. If you do hug singular, it'll say that you hug and then you can put whoever. Like, let's make sure I'm correct on that. Right. And then if you do hugs plural, you get the Nightbot hugs, is the hugger. And there's more. There's we've got the high fives. There's a lot of new ones. Okay. So right, there was no prejudice. Defendant already knew Kim Jensen was a person with knowledge of the case. Additionally, defendant was in possession of Kim Jensen's prior recorded statements to police and the grand jury. Those statements disclosed that the defendant's statements about Jared Bradigan were a form of venting frustration within her friend group. Even without the prior recorded statements, it is a reasonable inference from the contents of the text messages that they could be jokes, based on Ms. Jensen and defendant's use of euphemisms, emojis, and interjections. Defendant was obviously aware of this possible explanation because she crossed Detective Johns about and argued to the court that the text messages were not serious. That's true, but then they got additional information. Considering this context, there is not a reasonable probability that the defendant's preparation for and presentation at the hearing was materially prejudiced had she learned of these statements earlier. And now we have the knowledge of the truck. This part's not, I don't think, as important in terms of what they were saying. I mean, I guess there's some possible impeachment as it pertains to Detective Johns again. Okay, the court finds that there were no discovery violations, didn't suffer any prejudice. Accordingly, it is hereby ordered. And again, it's done without. Without prejudice. Well, she said that at the hearing. So, okay, so that is the September 23rd. So that brings us to the next hearing, which is October 2nd. So you have to, so Flash, if you want it to say that you hug, you have to do hug singular. So exclamation point and then hug singular. And then you can say whoever it is, and then it'll say you do the hugging. See, DSN did a great example there for you. Thank you, DSN. Okay, so unshare, reshare time. And we'll pull up the hearing. Is this the right one? Okay, October 2nd, here it is. Okay. We'll live. So there, for anyone who doesn't know Mario, there's Mario. That was Shanna's estranged husband at the time of the murder. And now co-defendant. And there's his lead counsel, Mr. Dreiser. Now, again, I pointed it out before. It's interesting because he's always in prison garb and she's always in civilian clothes, whatever the terminology is. Oh, spinny wheel. Oh, spinny wheel. Oh, spinny wheel. Man. Oh my God. Okay, just trying to get to where things happen. Well, the camera is now facing the door, so that looks like they're awaiting Judge Kite. Now they're back on the seal. Okay, let me see. Oh, there's more time. Hold on. Oh, there we go. There we go. There we go. So silly. Yeah, she's in custody. She's in custody. Yep, she's in custody, but they're able to, you know, we see that where like her counsel will bring her clothes to wear and she changes into civilian clothes for the hearings and stuff. Why is everything stupid with YouTube right now? Yay! Flash, did you figure out the command? Yeah, so singular hug versus plural hug.
I represent Mario Fernandez. I'm present with Shanna today, James Hill, and Frank Tassoni is on Zoom.
I mean, I feel like the audio, this is better than we get in Idaho, though, to be honest.
On behalf of Shanna Gardner, on behalf of ISC.
Thank you. Good morning. All right. Is there anything I want to take up first?
The parties emailed that trial date, shall we schedule?
Now there's Mr. Mizrahi.
The trial date we proposed is October 20th, the jury selection 2025.
Yep, October 20th. I believe that is still the date. I know it's at least October the same of 2025, so I would imagine it's the same date.
I believe originally there was a discussion about 3 weeks for totality.
Oh wow, for the trial.
Unfortunately, we don't have an agreed date as yet. I think we're close. It's just that the defense team, we have been communicating back and forth, but I got confirmation of the October dates from the prosecution this morning. It's not to their fault. They received the final dates last night. But
Hey, good job, Flash.
They're in trial right now, so I haven't heard back from them. So I anticipate that those dates may work. But the larger issue that defense, I can say both teams have, is that we're still in the throes of discovery and we're not picking dates. So we can't hold ourselves to any dates when we're still going through discovery. So the dates that we're proposing, which I think may work in October, is with a caveat that the discovery is completed no less than 6 months prior. So as long as we have all the discovery, and I know there's still some motions to compel outstanding.
Like those subpoenas.
So as long as the discovery is done, then we can anticipate 6 months from that. So I guess that would put us sometime in April if the state could complete. If not, then we would need to revisit the trial dates.
Okay. Let me ask this. So the state believes your case in chief would be what? And you're also factoring in jury selection.
Factoring jury selection only 2 weeks.
So what do you, tell me exactly. So you believe like what, a week of jury
I believe
selection?
jury selection will last a week. I believe a bill phase for both defendants will last approximately a week. And the billing phase will last 2 or 3 days. I'm building a little bit more time on the back end in case the bill phase and the jury selection doesn't take long. But we can, as we get closer, we can obviously cut from the back end of that bill phase stuff. But since we're setting out so far, I think it's intelligent to add a few days. But last week when we proposed, includes Veterans Day. It's not a full week.
Okay, I'm gonna go forward a little bit because I mean, I feel like it's, what do they all say? Not right. I feel like it's a bit not right for them to be getting this into the weeds as it pertains to the length, but, oh, spinny wheel.
But I think that I understand that y'all are in the middle of discovery. I just, like I said in the last court date, I think that if we keep kind of just going this path without any kind of end date or goal in the resolution of these matters, this case could take
Oh, sorry.
5, 6, 7 years. Because
What?
I think that the way things are going, I think that we all need, and it takes a lot of preparation. It's not like
Interesting.
a long trial.
So she seems to feel, I'm getting the vibe from her that she feels like this is dragging, like they're not where they should be with discovery, maybe. And she needs to like light a little fire under their butts, if you will. Interesting.
Lots of considerations, I think, on all sides. And I think the number of lawyers, and the earlier we get a date in mind, the better off we will all be. That will be marked off on everyone's calendar. We will make the appropriate sacrifices or whatever we have to do to make it happen. And I'm committed to give you all whatever time you need, but I have to be able to communicate within the circuit the number of jurors. That is not easy, and that's not something that you get turned around in a short period of time. So as much heads up, that would be a year from now, more than a year actually. And so, who is in trial that you can't hear from?
Nah, they weren't, Shanna wasn't even indicted until August of 2023. Mario was indicted in, I believe, March of 2023. Now, Henry, he's been in custody, I believe, since February of 2023. But basically, you remember, it took them almost a year, right? After Jared was killed, it took almost a year to make the first arrest. And Jared was killed in February of 2022. Oh, I am getting close. Oh, I know. Yeah, I know. I am getting close. The death penalty filings are November 6th.
Okay, I'll wait.
Okay, what's next? What's next, y'all? Are they doing anything else on this day? Okay, oh my God. There's the white noise, which is awful. Let me see if they do anything else. It looks like they're still approaching. Still approaching. Is that it? Might be it. But there's another hearing. One more hearing. Oh my God. Yeah, so the next hearing is October 30th. So the day before Halloween. There were not any interim filings of note. So after we do the October 30th hearing, the next thing is we're going to be getting into all the death penalty motions. Okay, we're going to go to the next one, and it looks like there's some excited arguing going on. So let me do this. Okay. I will update the date. Okay. We're getting caught up very much.
Good morning, Your Honor. Patrick Brody on behalf of Ms. Gardner. Ms. Peoples is present on Zoom. Mr. Bias will waive his appearance today.
I'm sorry.
And Ms. will waive Mr. Bias' appearance today.
Okay. All right. I believe Ms. People sent my judicial assistant a notice. I haven't had a chance to review that yet. I was,
Yeah, the courts, they all take a break over Christmas.
Yes, Judge. I believe at our last court hearing, or at some point, the court asked that we give the court a written notice of the pending motions, and that was the effort to do so, Your Honor. We believe there are two. One relates to the state filing responses to our motions, and the second relates, as the court knows,
So these are,
the grand jury testimony.
oh, the grand jury testimony again. Okay. So again, so there's Shanna, and she's got a cardigan on, and there's Mario. He's in the jail garb, as I've been calling it.
that one, and I believe Ms. People was referring to you.
Yeah, you're all good. You're all good.
Motion.
Yes, Your Honor. I know there's been some discussion. Our position is that this court is bound by the statute. The legislature has not given absolute secrecy to grand jury testimony.
So speaking right now is Mr. Karodi, and he is one of the other counsel for Shanna. So he's with the Baez firm. I don't actually know who this fellow with the shiny head. I don't know his name yet. That I don't recall seeing him before. I could be wrong.
As written in our motion, we believe those exceptions apply. The court is obligated to follow the law. We clearly have testimony by Detective Johns that has been given under oath that is inconsistent, at least inconsistent.
How weird would it be, right? Like, how weird would it be, right? Like them two sitting in court, like they're still married, technically. Like they're still married. And they're just like sitting there. Like, it's just so weird, right? Like, I don't know, man. It's like gotta be so weird. Like they're still married. I don't know. I just feel like it would be like, don't you want to like sit at the same table? I mean, they probably aren't even. I'm sure they're not allowed to. I'm just thinking about how like, and I know they were estranged, but in the like, if you take, let's say that there's a married couple that's co-defendants and they weren't estranged and they were happily married, right? And it would just be like awful, you know.
Or intentionally reckless or false with respect to material facts. We believe we've established that in our motion and otherwise in the evidence we're hearing before the court. And as a result, we believe the statutory exceptions, two of them apply. That would be the interest of justice.
So Shanna, Shanna is keeping her, Gardner is her maiden name, I believe, or whatever. It's her family name. Like it looks like she didn't take, I don't know if she ever took Jared's last name, but you don't have to take the other person's last, like that's an option, right? Like my mom, for example, when she married my dad, she didn't take my dad's last name for a while. Like she kept her regular name. And then at some point she took my dad's last name. So, you don't have to. Now, what is interesting is he's got two last names. But that could just be like sometimes people have that, but it's not hyphenated, which is what's interesting. So, yeah.
The witness perjured themselves.
Yeah, there you go.
That the court should release that grand jury testimony. I also think
it's more and more common these days for women to not take the last name. Then stop it. Oh my God, he's so funny. Sure. Mrs. Shortnuts. Yes.
As part of the court's analysis, that the court should consider that Detective Johns is not an innocent citizen who has been brought in off the street, who was involved in the case by happenstance. He was the lead detective.
Yeah.
And the courts of this state are clear that a police officer has less of a privacy interest than an ordinary citizen. And for all those reasons, Judge, we would ask the court issue an order for us to obtain the grand jury testimony of Detective.
The gentleman in the gray suit looks ready to go.
Is the state standing on the previous argument? Yes, Your Honor. I provided that case law to the court.
Nice camera. Nice. Let's just see the back of her head. Excellent. Well done.
I'll take that one under advisement. What are the state's position on the written motions?
I thought we had some discussion regarding this last time with people. The only instance in the court in which the
doing motion with potentially require one, but it's not the grand jury motion. We provided 2 cases at the court date. I don't think that there is a requirement under the law at all, or that we should be bound to file in response to every single motion we file.
There's little Missy again, or whatever I've been calling her, little lady. There you go. And see, that's another thing. And I have to say, I know about your Angel Baby's ex is not, assuming there's only the one that you've talked about, is not a good person, to say the least. But I will say that I do love that this is a new thing that we're seeing, where men will take, the wife's like the swap of like the gender role reversal and take the other, a dude taking the lady's last name, if you will. I think that's super cool. I love it whenever you have gender norms flipped on their head. There you go. Yeah. Well, I mean, I wouldn't be surprised if you're, oh, the Enrique, that's true. So just the way that every time I search on the court docket, the way it has you do it is you have to put Mario as the first name, and in the last name box, you have to put Fernandez Saldana in that order without a hyphen and in the same box, or it will not come up. But that's, I don't know. This is how the court record has it for the search thingy. Yeah. Isn't that cool? Yeah. Super cool. Love it. I didn't even know about the Enrique part though. That's a lot of names. She's like, I'm not going to provide any case law because we don't do that here. Dying. And I'm sorry, there's not any close, or wait, well, let me see. Yeah, unavailable. And I know it's hard to hear because bad audio on this. Some of them are better than others, but we'll do our best.
I'll respond to both of these motions by order. Okay. One of the other issues was the status of the taint review. And
Taint review.
I wanted to know what the defense, how you all got together and thought through the last response that I had.
Your Honor, my understanding of the record, James Hill, there was discussions late last week with regards to alternatives.
There's Mr. Shiny.
Based upon that issue that came up. So there's been discussion with either Clay County and Nassau County handling the taint process.
Mr. Shiny.
Position with that, we're in agreement with that. As long as if any issues come up in that taint review, that whoever is doing that taint review reaches out to the defense and not the state, so we don't recreate the issue we dealt with earlier in this case.
I agree. Mr. Bias is joined as well.
Do you guys think that Mr. Shiny is a swimmer? Look at those shoulders.
And the officer is present?
Yes, Your Honor. Officer Simmons, he's sitting in the bench right here with the sheriff's office. He's happy to drive up and be this group.
Okay. Officer Simmons, good morning. Could you come forward, please?
The bailiff getting ready for some action, maybe? Oh, no action.
Officer Simmons,
very cool.
I appreciate.
What's your middle name, Flash? Well, we don't even know your first name.
The individual that was going to do a tape review to actually appear in court, so I do appreciate your appearance. This is
some GTL, maybe?
Where it is unusual / not done often as far as the type of evidence and what you would be asked to do. I last time entered an order for the tape review and the process and procedure.
I want to know who she's looking to.
And the main issue that came forward in this case was
it sounds like whoever she's talking to is, oh my God, that pause. Sorry, Judge Kite. Oh my God. Okay. It seems like whoever she's talking to is going to be the new person in charge of the taint review, maybe, but they haven't shown them. So show thyself. Oh, I knew Christian. That's right. I forgot it was Christian. I like that name though.
Maybe something needed to be clarified.
A water skier. I mean, how many? of all the obscure sports, right? She has, and I agree, she has gained some weight. She has gained some weight. Yeah. You know, it's so funny, right? I mean, well, it's not funny, but it's a thing, right? Like when you see people when they're in custody, some people will gain a lot of weight, other people they'll lose weight, you know? Lori Vallow, I will say, for one thing, I will say has been pretty consistent. And same with Sarah Boone, I feel like. But you know, anyway. But yeah, she has put on a lot of weight. She has put on some weight, yeah. She is a young judge. I think she's very beautiful, and I like her. She's got like the hipster glasses. And I like her. I mean, I don't feel like as I say what I'm saying, I'm like, oh my God, I sound just like Lori, you know. What I was going to say is I don't always agree with her rulings, or I don't always agree with her decisions. But I do like her demeanor, and you know, I think overall she seems to be balanced, right? And yeah. Lori, would you say she's thin? I wouldn't call her thin necessarily, although it's kind of hard to tell in the, you know. Is she 47? She does not look 47. Holy crap. Really? Nah, she does not look 47. That's amazing. I mean, again, apart from being a judge where you're like, well, they have to be a certain age, or like probably, right? Like I would have guessed, like, what would you guys have guessed if you, again, removing the judge thing, but if you had to guess, and honestly, the camera quality isn't even as good here as it is in other times, but like, what would you guess for her age? Like, just like, what would you guys think? I'm terrible at this, but I'll play along too. I mean, really, again, if you look at some of the other hearings from like the same, you know, not like they're still in the same time period, right? But the camera's a little bit better, you know. I would say it's, you know, she probably looks like I don't know, 28 to 30 or something, mid 30s. Oh, okay. Really? Interesting. You know, it'd be interesting to see what she wears when she's not wearing the robe though, too, right? Because style. Oil of Olay, not sponsored, by the way, not sponsored. That's hilarious. That is hilarious. Is that what Mrs. Shortnuts uses?
The taint agent was reaching out to the prosecution.
Yeah, you guys, in case anyone didn't believe me when I said, by the way, the quote unquote taint agent was reaching out to the prosecution, let's just hear Judge Kite say that again, because words we will probably never hear again in a trial, hopefully.
And when there were issues or
incredible,
maybe something needed to be clarified, the taint agent was reaching out to the prosecution.
You don't even have to know anything to be like, pardon, what? In what insane, some distant universe or other dimension are we talking about? Because not in this, like, it doesn't even compute.
And that caused issues because the information that you potentially will be looking at could contain.
Yeah, she's definitely talking to the new prospective taint agent.
So the process that I had put in place mainly was gleaned from federal law. They deal with this more often than state court.
I wouldn't believe, I don't know. I couldn't, I mean, I don't know everybody's age.
To a blind review. That is, if there's an email or a phone number or something associated with the list of attorneys that
well, having said that, I know Fender's pretty young. I'm trying to remember exactly how Fender, I think is like, does anyone remember? I think Fender is like, I don't remember actually. I think Fender's in her 20s, but I can't remember for sure. I found like, but I don't know everybody's age. Just some people have said how old they are.
You are to redact that from.
I mean, Angel Baby also looking great for her age, though.
Whatever that email or whatever it may be. The parties have agreed on that.
Oh wow.
So you won't have to do any analysis. It is a true filter.
Candace also looking great for her age. Are you 55? That's insane. Are we? Sorry, I'm just wrapping my head around this because Candace is 55. I had no idea. Wow. That's amazing, because not only Candace like looking great for age, but also Candace, for anyone who hasn't heard, is also training for a marathon. Good for you, Candace. Wow. DSN. You know, the thing about DSN's picture though is, you know, what's the word? You know, ageless. Like it's an ageless picture, right? Like you're never gonna. What's the word I'm looking for? 56. Wow. Yeah, I mean, we do have, like I said, like Fender, I can't remember. Kid Smith's, I think, is like in her 30s, but Fender might be the, well, I guess apart from Flash. Maybe you might be right, Flash. You might be right. But see, I don't know everybody's age, right? So that's the thing. Doesn't she look wonderful? I totally agree. But you as well, Angel Baby. We got a bunch of good looking people here at the Squirrel Crew. You weren't born in the 90s. I can't even. Wow, you were born in the year 2000. That is insane. That is insane. Yeah. Wow. That's crazy. That's cool though. I mean, for people that are young and have already learned the amazingness that is trial watching, good for people. Good for people. And also to be learning about their law and their rights. You know, when I was Flash's age, I definitely didn't have the appreciation. I don't even think I had ever seen a trial. I mean, no, I can say for sure I hadn't. I didn't even know it was a thing that you could even do. So yeah, crazy, right? Yeah, everybody be looking good up here in the Squirrel Crew, right? But Flash, you might be the youngest. It's just sometimes I'm trying to think. And we have some new people as well, and I have no idea how old they are, but you know, but y'all are killing it though with the ageless situation.
Been attached to an email or a document that is created, you might have to look at it. If there is a question about it, you're to identify it, and then your
Don't ask the prosecution.
final Taint report will go to the defense, and I'm going to put into place a notification. I'm going to ask that you email all sides that you completed the report. I'm going to amend the report that way. I'm going to amend the order that way. That as you review it and as you complete work, email the court and all the parties. You're going to send the report not to the state, to the defense first, in the order they have. I think what did I put? 15
Yeah.
days? I can't remember. I believe I gave them 15 days to review the redacted report. If they have objections to anything, then they're going to file motions. So the thought process is.
It's interesting too that you mentioned that, because Flash has an affinity for some of these vintage trials. We've talked about that a lot. And the difference and the style, you know, or I guess you could call it style, but in the vintage trials. And Angel Baby also had to testify at a trial, and she has shared about that previously. So that's why I feel okay saying that. But she was not a criminal defendant, but she was. I'm trying to remember. Weren't there some? Wait, hold on. There was a crazy circumstance where like they tried to say you were, but you weren't, right? I'm sure you'll remind me in the chat, because I remember thinking like that was insane. But I know you ended up testifying against, for your ex's trial. And he was convicted and I think still incarcerated. Yeah, you were the victim, right? I just remember thinking maybe you were the victim, but they also charged you, and then they realized that was a mistake and they dropped it. Am I getting that mixed up with something? George Zimmerman. Which one was that? I know the name. I think I know the trial, but I can't remember what that is.
If there are any questions, you can put any questions, information in that redacted report.
Right, attempted murder. Right, and it was self-defense, right?
It should not necessarily be disclosed because it comes to the defense.
That's awesome.
Whatever objection, so you should not worry about that. Okay. My understanding, and the state can correct.
Oh, right. Okay, yes. I remember that.
Detective Simmons will not be doing the extraction. That's already been done. So you'll have the extracted information. We'll be able to do searches looking for the identified lawyers. There's a lot of.
Okay, I'm going to go forward a little bit. So they're just talking about the specifics of how they're going to extract things. Let's not fuck it up this time, state, please. Judge Kite. Judge Kite. Yeah.
Assume that if the state attorney's office is involved in transferring the unredacted extractions, that'll happen in like a single day. It'll be a two-prong that they're not going to go hang out at the state attorney's office for days, because that's obviously our concern, is that they've had access to and custody of these unredacted extractions. So if they're involved in the transfer of these extractions, we don't have
Okay, we're still talking about extractions. See if we get into anything else here.
About what evidence maybe make it into a situation, if there is ever a situation and you need clarification, if you would just say there's an issue, you can email court and all parties, we can probably get it resolved in some way through a court date. Where some of the issues.
Here it goes. Here it goes. Yeah.
Was contacting the prosecutor, and that just defeats the entire.
He was the attorney for the Menendez brothers.
By the prosecution, because obviously the information that
as well.
Reviewing is very sensitive to the defense, and so to get guidance from the prosecution only about litigation or maybe me intervening as appropriate, just kind of defeats the whole team review. Otherwise, the prosecution just could look through it themselves and answer their own questions. So I, first of all, thank you, and I know that this is
wow.
I appreciate your being involved in this, and ultimately,
right.
You may be needed for testimony depending, but I do appreciate your willingness to help us in this regard. Does anybody have any questions or concerns that you'd like to discuss?
I just want to make sure for clarity that it would only
so,
be Detective Simmons.
So Angel Baby, are you saying you prefer to go into a trial without knowing anything about it ahead of time? Like going in blind or something, as they say?
This process, there's not going to be
ESN is thinking, maybe?
Somewhat in a sterile manner, so nobody else has access to his work on it. So I work on my own machine, secure lab.
Okay, and obviously,
gotcha.
Any of the information that may be in that report, so it only goes to the defense, and then the defense files whatever motion.
I did that with Karen Reed because I knew nothing about it going in, but it's not like a thing that I don't know. I'm trying to think. I haven't done that intentionally because usually, I like covering pretrial. Like I love pretrial litigation. So usually if you're involved in the pretrial, you want to see it through, right? So, but the pretrial litigation is really interesting and a lot like this one, BK, Brian Kober has been really interesting as well. I guess actually I take it back. Casey Anthony, though, I will say, came in blind, didn't have, we started with day one with opening statements on that one. So that one would be like a more similar to that. Oh, it's way over your head. Well, if you have any questions, I'd be happy to explain what's going on. Just, feel free to ask. Oh, commenting. Right. Gotcha. Yeah. Yeah. He's represented a lot of people. And who else? Who am I thinking of? Or no, I'm thinking of, didn't he also, who was it that represented one of the slimy people? Like, what's his face? Who represented, oh God, what's his face? Not Epstein, but the dude, Wine. Oh my God. Started the the Me Too movement. The director guy, what's his name? Weinstein. There's so many, they all have similar names. Who is it that's representing him? Harvey Weinstein, yeah, because I remember didn't he have one of these attorneys that we talk about a lot? I'm trying to remember. Oh, that was Alan Jackson. I just remembered. It was Alan Jackson, wasn't it? No, it's Alan Jackson. It's Alan Jackson. It's Alan Jackson. It's not Bias. Oh, I've never even heard of that. It's Jose Baez. Are you sure? Who was it that Jackson represented? Because Jackson represented somebody who was supposed to be a bad dude. So Candace says it was Jackson. Okay. Surely we can get, yeah, I thought it was Jackson. I'm sure it was. And that makes sense too, because California. I mean, Jose Bias stays in Florida. Yeah, do your research and let us know.
And then we'll litigate from there. But your work on this is much appreciated, and it seems like you're going to be potentially starting from scratch. And so I'm going to set some status dates. I thought that was maybe appropriate. I'm not rushing you. I just want to know kind of where you are in the process. If that's okay. So I understand the projected date might be December. You might start your review, and it may take longer, but like maybe on a 30-day basis, just kind of check in to see where you are with the.
Check in, good old check in.
Does anybody else have any concerns or questions?
No, Judge, and I believe you said this, but if the detective does have any issues, he's
Yeah.
let us know if there's an issue and
True.
say what it is.
Okay. Yes, I need to be more. Yeah.
There's Shanna's head again.
That there's an issue.
Oh, that's awesome.
Okay, I'm not sure how I would write that.
Did you watch with EDB?
Okay. If there's an issue, I'll figure it out.
Oh.
Right. Right.
And Marco Mara. So I don't think I know that attorney, but you're saying that whoever it was amazing. So this dude was be amazing. That's cool though. Yeah. So what was I thinking? Oh yeah. I was thinking about, I was having a scroll tangent in my head, but Angel Baby, did you watch with the, with EDB at the time? Or were you watching it when it was actually happening? Yeah. So then the answer would be yes. I mean, remember, I'm just going to say, it's not, whenever people are acquitted, it's not that the defense got them off. Let's make sure we're not burden shifting people. It's that the state did not prove their case. Because if the state proves their case, it doesn't matter what a defense attorney, they can come in with a magic wand. They could be Gandalf. Doesn't matter. If the state proves their case beyond a reasonable doubt, barring jury nullification, which we hear about, but like never happens, right? Barring that, then it doesn't matter. There's nothing a defense attorney can, I mean, they're going to try their best, but in other words, people say the same thing all the time, right? About Jose Bias with Casey Anthony. And it's, yeah. You know what I mean? Oh, thank you. I'm glad you enjoyed it. Yeah. So, and that's the point, because if you didn't have defense attorneys that do a good job and, the state wouldn't bother to try, right? Like the only thing that keeps that burden in check is the defense attorneys. And that's the point. That's the point, because that's why it's set up the way it is, so that if the state can prove their burden is to prove it beyond a reasonable doubt. And that means like there's like nothing that could make you think otherwise, right? Like nothing could make you think otherwise. Doesn't matter what anybody else does. And if in fact someone is, a defense attorney is, whatever the strategy may be, depending on the case, but if it's making you doubt that the state has proved their case beyond a reasonable doubt, then they haven't proved it beyond a reasonable doubt, right? So it's just important to make sure that we are using the right languaging too, just because, it matters. Oh, okay. That's right. Massachusetts. I didn't remember that, or that Aaron Hernandez was in Massachusetts. For some reason, I guess I assumed he was Florida. But yeah, so like, but again, to this point, so like, he could totally be despicable, right? And I don't disagree with you. I don't really know much about him, but from what I know, just generally about that case, yeah. But again, what it means to me is the jury looked at the elements of the charges, right? And they looked at the evidence and what the state presented, and the state didn't meet their burden. So, and I don't know, was there an affirmative defense, do you know, in that case? Like, what did the defense do? Did they have like a case in chief? Did they have an affirmative defense? Or did they just like poke holes, cross-examine? Be interested to know.
I'll figure out how to say it. Okay, so I'm going to, we have the contact information for Detective Simmons. In order, I'll put my contact information for my judicial assistant, the attorney's email is a part of the review. So before you leave, Detective Simmons, I'd like for the parties to have.
So there he is. We're looking at the new Taint attorney right there, Detective Simmons. There he is. We can see part of his head. Godspeed to you, Detective Simmons. Please, may you not breach any attorney-client privilege. Well, he's allowed to see it, but don't give it to the prosecution. I'm sure you wouldn't. Okay, let me rephrase that. If the prosecution asks you for any attorney-client privilege, report directly to Judge Kite. In fact, I think she already told him that. But
if you would give him the contact information if he wanted to be placed on that essential email.
yeah,
That would be helpful.
interesting.
To contact the parties, and maybe because there are so many lawyers involved that maybe you only put two, and then those lawyers for both defendants can disseminate out.
Right. Thank you, Flash.
Each defense team.
Flash bringing the fun facts.
You have the assistant state attorney's information, and so if something.
And I think to this end, it's so interesting, isn't it? I think that's true with all of us, right? Even if we even just think about back, like watching a trial from even a couple trials ago, right? With every trial, you learn something. Every single trial, you learn something. And I think that's why it's so great. Like, I just love it for that for so many reasons, but also I think it makes us smarter. It makes us more observant. It expands our perception, and it keeps us, we have to have an open mind, and we understand the law. I mean, there's so many benefits, but one thing that is really good proof of that, right, of just all of the benefits, is that there's not a whole lot of things you can say about it where if you go back to just the same thing from 6 months ago, that it would be so different. But you can say that about trials. You know what I mean? Like, I can definitely say, at least for me personally, that with every single trial, I learned something new. And if I were to go back and watch the same trial from even a couple months prior, I would definitely see things I missed and maybe have different opinions even, but and that's why I feel like you can watch trials. I mean, well, y'all know we've done it on this channel, right? We watch them more than once because you will always learn something new. So yeah, it's a great opportunity.
Information. And then I will have the order sent to you directly. And then once I file it, I'm going to send the order to you through my judicial assistant. Her name is Sylvia Wilk. And it's WILK. Detective, do you have any?
It was a 6-month case? That is insane.
All right. Well, again, thank you. I appreciate you driving up as well.
6 months.
All right.
See, when you put it and you compare, like, BK being long, right? But then you compare that to like OJ and Phil Spector, it's insane, right? Like, yeah. But you know what? The thing that, though, DSN, that is important is that you recognize that. That's the thing, is that you recognize that. I think that, I mean, everybody, humans, all humans have, like, we're born, right? You know what I mean? Like, it's really a matter of, I think in terms of confronting our own bias, it's really a learned skill, really, in a lot of ways, right? And like, it's a matter of like acknowledging and accepting that everybody has it, and then striving to be more objective. It's like a skill that you practice. But I think that where bias is the most dangerous is when people don't recognize it, and they don't have an open mind to, if they get new information, they're not willing to change their opinion or whatever. I don't know if that's bias, or I don't know what that is, ignorance. I don't know. But like, again, I always give the example of like flat earthers, right? It doesn't matter what you show them. The earth is flat. Like, I don't know. Well, what would you guys call that? But, and then again, I don't know, that's really biased, but there's an overlap there, right? Where like, I think acknowledging that you have a bias right there would in turn also then be saying, I understand I have a bias. And so that can view how I perceive things. But again, just the acknowledgement of it, I think it still allows room for growth, if that makes sense, or seeing something a different way.
What else?
Judge, I can just update the court. We did another round of depositions last week. We have deposition dates already set aside all the way through December 11th. We just got that additional evidence.com download that was mentioned the last.
Evidence.com? Are you joking me?
memory serves.
Evidence.com?
And those are the past couple of days since we've received them, as discussed. It's
What?
now, but we did receive it. We've been in constant communication with the state about questions, and we're doing the cross-referencing process, but that'll take a significant amount of time before working through it.
Is that platform working better?
It's what we're used to working with more. So aside from the previous platform, this is one we're all accustomed to. So it's literally.
So yeah, because they're not going to be using what's its face anymore.
Evidence packs. Took about 18 hours to download.
Next point.
Cell phone downloads and a lot of forensic information. So it's working well thus far, but it's a lot of information.
Okay. Just for my understanding, so what has been occurring before this? Like y'all are getting hard drives over. And so is this duplicative or is this new information?
It's a little bit of both. So to give a good example, one particular download may be, I guess, basically several gigs. And then it'll be the same file that we have previously had, but a previous file may be smaller or maybe larger, but it'll be labeled the same exact thing. So we do stay in contact with the state to see what may be different, but we do go through it to compare what is the difference in the significant size difference of particular files, some of which are cell phone downloads. But when it comes to financial records, subpoenas, returns, things of that nature, when we're noticing just file size differences, it's requiring us to go back and go through to see where that difference is and any discrepancies or anything that may be missing. So as we've done before, we're compiling a list of questions and things that we believe are missing as we're working through it. So we've restarted that process with this new download while going through and trying to compare to the previous discovery that has been provided to kind of cross off that list. But it is, as mentioned before, and I think the state even acknowledged, they've even had where computers crash going through this. So we're trying to do it in a way that doesn't create more issues. But in that, it does take time to do that.
How is the state
Right.
for discovery purposes?
Okay, I'm going to go for a little bit. So because they're just, good old discovery. Judge Kite is thinking. Evidence.com. That blows my mind that is the thing. Interesting.
This was everything that the lead detective has. It's been placed into one evidence.com cloud download. We're providing our camera the same platform. It's sent to defense, and I download the same download, which is basically a copy of the evidence.com laptop. Obviously, minus the devices that issue with the prior discussion on record. So I'm having to figure out some practical way to put that into a court exhibit so that someday when we're doing court, we look at the court exhibit and know exactly what each side had.
So now I'm going to bring up what Ms. Peoples brought up, which is I want to make sure that we're all operating on a date that is realistic. The defense, if y'all have depositions that are set into December, I don't know how far y'all are working in to witnesses, whether the defense has, maybe you can't answer this question, but you're going to depose, like at the last case management hearing, I can't remember the number of witnesses. Are you prioritizing? Are you talking to every single person?
I guess the best way to answer that question, especially based on the nature of this case and being a death case, we're making sure we do our due diligence with every single witness the state has listed. Albeit some of those are 10-minute, 20-minute depositions. But even with this last deposition, one of the witnesses that was a 20-minute deposition contacted the state with new information they had remembered. So that's only happened twice thus far as some of these, I'll call scene witnesses and ear witnesses. But as we get farther down the road to more, I would say, substantial witnesses, that is where we're working through the discovery to try to get to that point. So when it gets to the Google information, the geofencing, wiretaps, things like that, that's now information that we're processing.
Wait,
but will take
did he
time.
say,
So we're trying
what
to
did he
get
say? Did you say geofencing?
farther down the road to more, I would say, substantial witnesses, that is where we're working through the discovery to try to get to that point. So when it gets to the Google information, the geofencing, wiretaps, things like that, that's now information.
Yeah, he did say geofencing. Interesting that he said geofencing. Huh. I don't know that I know of a case that has used that except Delphi. You guys know? What other cases have used geofencing? Because that's that makes sense because I've always been thinking to myself, where did they even get their first lead, right? Because it took them so long. And there doesn't seem like there was a lot of forensic evidence. Interesting. Wow. That is very interesting. because that's a big deal, the geofencing. So Flash asking about why they will do that. They will film one trial, not the second. My guess is that one of the parties or both the parties agree that potentially having cameras in the courtroom could have been a potential cause for a mistrial. Of course, they can't inquire about the jury and ask, and so they won't ever know. But I guess it's sort of like just out of caution to make sure that did the camera's presence have any effect on the jury? They don't want to spend all that money to have it tried again and then have another mistrial. That's what I would think. Geofencing, I'm probably not the best person to try to explain that because I'm not tech savvy, but it's like basically, or maybe did they do that in Lori Vallow? They may have. So basically my understanding is that it's like, you know how like the way it normally works is you've got people that you know were at a certain place or certain time or whatever, like, you know, search warrants, right? To get people's phone records or whatever. So with geofencing, it's like you've got nothing to go on. So you, I don't even know how they really do this, but they get permission, I guess, to, through like the cell towers to receive the records of every single phone number that used that tower in a certain time frame. So they see all the phone numbers or the phones that were like in that proximity. It might not even be having to use a tower. It might even be like, and like, you might not even be that you used it to make a call, right? I think it's just like if you're in that proximity. Basically, so similarly to like what we were talking about Koberger with like the IGG and the people. In other words, if there's no way around it. There's going to be a lot of people who are innocent, who have nothing to do with any crime, who are going to be put into the pool and then have to be ruled out. Kind of a similar thing. Where, yeah, so, you know, there's going to be a list of whatever, hundreds or thousands of phone numbers, right? And then they go through each one and then they try to see which one looks like it was someone who maybe has something to do with it. Is that, well, wiretap is listening to people's phone calls. This is getting the phone numbers to begin with because you don't know somebody. It's like, in other words, this is the way that you even learn that the phone number exists or that, and then the person using the phone exists, right? Wiretap is very different because that's like way more, farther ahead. That's when you've got enough, and it takes a lot to be able to get to get permission to do that. The standards are very, very high because that's considered to be a huge invasion of privacy. But that, in other words, there you would have to have people who you really feel like are involved, and you're just needing that last piece of evidence to make an arrest or whatever. Like the probable cause there is really high. So, like I'm trying to think of an example, like they had no idea who Henry Tennant was, right, in this case. So my guess is they did the geofencing because they had to see what all phones were in that area in that time period, and then they went through everybody, and then they probably looked at what, and then figured out what, you know, who the vehicle, right? If let's say their first lead, I don't know what it is for sure, but probably the first lead was that somebody saw the vehicle, the blue truck or whatever, right? And so then they had to figure out, you know, but there's a lot of blue trucks. So then they like probably had to try to go, you know, narrow it down by, okay, what people were in this area based on their cell phone numbers, and then go from there and see, okay, now how many of those people had a blue truck? That's just sort of what I could see being the case. They do have wiretap. They do have wiretaps. So they have both. They have both geofencing and wiretaps. But geofencing is really uncommon. Like I said, the only other time I can think of it being used is that, to my knowledge or in my memory, is Delphi. Maybe with Lori Vallow. Maybe. No. Wait. I remember it came up. It came up and it was like almost geofencing, but not quite type of thing. And I remember it was really controversial because geofencing is really frowned upon. That's why I was shocked to hear him say it, because it's a big deal. Because again, when you think about people's invasions of their privacy, people who have nothing to do with a crime, it says it's kind of like being able to get a search warrant for people without any probable cause, right? Because they get the phone number, and then they're going to have to see who the person is that has the phone and your location. They're getting information about you, and there's no probable cause. Again, similarly to where if you're someone who donated your or put your DNA on one of those websites, right, for IGG, and they get your personal information that way, right? A similar thing. It is akin to, you know, it's the Fourth Amendment, right? For, you know, search and seizure, they have to have probable cause. Are you saying, did they do a geofencing in Karen Reed? I don't think so. I don't think they did wiretaps either. I mean, they just had the red solo cups, right?
Information that we're processing, but will take time to get through. So we're trying to get rid of as many of the, I would say, less substantive witnesses as we possibly can, and do the best we can.
Obviously, in the year, this investigation was for March, so our foundation after this, every single they can take it over their they do but I did let the start know in New York and the state side, they're creating a proposed witness list for trial purposes, witnesses for trial purposes. And at least give them notice of all of these 100 witnesses listed, we're calling these entire jury for trial. As best we can, we talk to industry and talk to the get too. But that's the decision we've done. And then remember, I asked if the state would also claim for potential penalty case as well.
Yes, ma'am. So I have, now that given the guilt case discovery, I'm preparing sentencing case discovery. Most of it is duplicative because the aggravators relate to different facts of the case itself. There is some information that I would intend to potentially use or not use either as rebuttal. Probably most of it can be rebuttal, but I anticipate they would put in mitigation. But I know it is now. I have to get to it now.
Okay. When do y'all want to come back?
I'll defer to defense.
Judge, I really, at least on behalf of the Fernandez team, my understanding we have depots set through mid-December, and understanding Detective Simmons' process, I would defer to the court maybe to structure the next pre-trial to be maybe with the status update you're looking from the Taint agent.
Taint agent.
But I think I would even suggest maybe even to the new year, but I defer to the court.
So they're going through some more scheduling. Let's see if anything else.
That might be better. And I would ask Detective Simmons for a status update the week prior, so that there's time for people to enjoy the holidays.
No, the only date I would suggest that week, just because we have depots that week, as well as maybe Thursday the 12th. I don't know what your
When is
process.
those?
The 10th and 11th of that week.
Perfect.
The 12th.
Yes. You need to check with your team or?
That's fine, Judge.
Is it?
For status conference.
Yes.
Yeah,
Okay.
that's fine.
All right.
Your Honor, would that be 9 a.m.?
Yes. All right. I will see you all back December 12th, 9 a.m. and that's for pre-trial.
There you go. There you have it. Oh, I know about, yeah, I know, yeah, I know Brian Walsh. I know that case. I just, I can't really add, like, I've got a lot of, I'm doing so many cases, you know what I mean? Like, can't do them all. Can't do them all. There's Shanna going to leave. Let's see. Got her card again. There's Mario. There they go. There they go, back into custody. God, it must be awful. Can't even imagine. So yeah, so that brings us now. We're like up to speed, y'all. So the next thing that'll be happening is the death penalty motions. That will be what we cover next with this case. And I believe tomorrow, I think I'm going to be doing Alex Murdoch's appeal part 1. But of course, I'm sure there will be other things soon. We'll do another Casey Anthony, and we'll, of course, next court filings come out in BK. We'll cover those, of course. And yeah, so I did see something about how Luigi Mangioni's federal, I guess it's like, I haven't even gotten a chance to look at it because I've been streaming, but like his federal, I don't know if it's like his indictment. Let me see. Let me see if I can see what it is. It's like, maybe it's like the arrest warrant. Let me see. Yeah, no, it's not an indictment. What am I talking about? It would be, let me see. I can't find it. I got a notification earlier and I just didn't even open it up. But yeah, something like it's probably the it's like, in other words, the feds don't usually release stuff, right? So it's like the federal, it's got to be like the probable cause for the arrest. And it's got like pictures and it outlines all the stuff from what it seemed like. So that's something that I could go over to if anyone is interested. No, we won't have cameras. We won't have cameras, but you know, it could still be interesting to see just how do they put their investigation together with what they had and across different states and stuff, you know? Right. I see what you're saying. Yeah. I do already know it. Yeah. I remember, you know, a lot of these cases, I end up hearing about them like when the murder first happens. Like, so with Brian Walsh, you know, I learned about that right after it happened because there was like, you know, it was crazy circumstances and, you know, all the evidence that they had right off the bat against him. And then of course I learned that it's Massachusetts and it has that same judge. What are the two cases that you're very interested in? I guess you're probably saying the Luigi, the Mangione, is that what you're saying? And Brian Walsh maybe, but Corey Richins, yeah. And that one's been tough recently with that judge and the cameras and Courtney Clenny. Okay. That's interesting. Yeah, I mean, yeah, I'm definitely skeptical too of the Massachusetts courts. Yeah, I mean, those are definitely interesting cases as well, you know. Corey Richins is going to have a tough time from what we've seen so far. I feel like Courtney Clenny, I haven't heard as much about. I know there was a hearing just recently, but you know, I guess she's probably going with like a self-defense type of thing. And then with Corey Richins, I guess just like, I didn't do it. It wasn't me. He died of a drug over, like he took the drugs willingly or whatever. But yeah. Right. Yes, that's correct. Yeah. I mean, Ezra did the same thing. Ezra McCandless did the same thing. Sarah Boone did the same thing. A lot of people do it, actually. Are you saying they asked for bond every other hearing? That's Courtney or Corey Richins? Corey Richins just has had a lot of bond hearings. They have. So and remember, yeah, I mean, you guys, I'm sure know, but she Googled luxury prisons for the rich or whatever. It's just like not the sharpest tool in the shed, as they say. Yeah, both. Yeah, I'm trying to remember who Courtney Clenny's attorney is. So I feel like she probably was able to hire somebody notable. Good night, DSN. You go scoot on out. Please come back again. Don't be a stranger. We love you. We love you and we missed you. Don't get carried away with the sports ball now. XOXO back to you. Yeah, the OnlyFans. See, OnlyFans just makes me think now of Massachusetts, like the OnlyFans, you know? I think it was Kit Smits who made that connection during Karen Reed, and I was like, amazing. The OnlyFans. Yeah, the walk the dog. It really was. It really was. Yeah. Like, what are you doing? I mean, there's, there's people who self-snitch, and then there's some people who like self-snitch without even realizing that they're doing it, Yeah. It's clear from all the things, at least that I know of the case with Prairie Urchins, that she's not got a whole lot, no offense, but like the intelligence level is maybe not even where it is, maybe with even other defendants that we know. Yeah, please do. I don't know how you keep all these cases straight. Flash, you follow so many cases. It's like, I mean, I feel like at any given time there's like 40 or something. just crazy. I really liked Sky Lazaro. She comes on STS every now and again. But she's not Corey's attorney anymore, but I really like her. And Corey almost got her in trouble too with that walk the dog situation. So, but y'all, I'm going to get some stuff ready for tomorrow for my students. Actually, that reminds me, I need to finish fingerings for that Mozart concerto. And I forgot about that. Yeah, I need to get that finished for one of my students, and other things for the live streams for tomorrow and whatnot. But it was awesome hanging out with you guys and going over all these pretrial happenings. Yeah, you could. That's clear, Flash. That's very clear. Yeah, so knowing a whole lot of trials. So good night to you as well, Angel Baby. Hugs to all. Hugs to everybody. Thanks for being here. Y'all are awesome. We love the squirrels. And thanks, guys, for just being awesome, as always, as well. And I will see you guys soon.